Hello CA Foundation students, I hope your revisions for May 2026 exams are going on really well. This is part C of the Companies Act revision video. We have already uploaded the Indian Regulatory Framework, Chapter 5, the LLP Act, the Companies Act Part A and Part B, and this is the last part wherein the remaining topics, that is all the doctrines, are going to be covered. So first, what are the three doctrines? Let me ask you, I know you will be able to recall at this point of time. The doctrines are doctrine of constructive notice. The doctrine of constructive notice is what we are going to look at as the first topic of this video. Then there is doctrine of ultra vires and there is doctrine of indoor management, right? So first let's look at doctrine of constructive notice. Now before going into the theory, I will give you a simple background of the doctrine of constructive management, constructive notice. What does constructive notice mean? Constructive notice means that someone assumes that you have knowledge of this fact. How? Say for example, you enter into a shop, right? And when you enter into the shop, outside they have already written, or at every place they have written that the product cannot be returned, right? So even if they do not specifically tell you, they are going to assume that you have read that hoarding or read that banner which says that no refund, no return policy, right? So that is constructive notice. Similarly, as per the Companies Act, now coming to the Companies Act, what does doctrine of constructive notice mean? See, there is a section 399 of the Companies Act which says that there are certain documents which are filed with the company and which are filed with the registrar. Company has to compulsorily file documents like MOA, AOA, certificate of incorporation with the registrar. So every person has a right to inspect these documents which are filed with the registrar. He can inspect those documents, take copy of those documents, he can read those documents by giving a nominal fee, right? So if this right is given by the Companies Act to every person, then the act also presumes something. What do they presume? They presume that if we have given this right, then it is your duty to read the documents if you are entering into contract with the company. Before entering into the contract, you should have knowledge of the documents like MOA and AOA. We assume that you have read these documents, you have understood these documents in the true sense, and after that only you have entered into contract with the company, right? So this is the simple meaning of doctrine of constructive notice. Now coming to the keywords. What does doctrine of constructive notice mean? Section 399 provides that any person can inspect by electronic means any document kept with the registrar or make a record of the same or get a copy or extract of any document, including certificate of incorporation on payment of prescribed fees. That is what I told you. Now, the memorandum and articles of a company, when they are registered with the registrar, they become public documents because they are available for inspection to any person on the payment of nominal fees. In other words, section 399 confers the right of inspection to all. It is therefore duty of every person dealing with the company to inspect its documents and make sure that his contract is in conformity with their provisions. How does he ensure that the contract is in conformity with the provisions given in MOA and AOA? Because say for example, I want to purchase a laptop from ABC Limited, right? If in the MOA of ABC Limited, the object clause is construction of so and so, like construction of housing complexes, then is the company authorized to sell laptops? No. So that is what they are saying. You should always read the MOA of the company before entering into contract and confirm yourself that whatever contract you are entering into, it is within the powers of the company. It is conforming to the provisions given under MOA and AOA. But whether you actually read or not, whether a person reads them or not, it will be presumed that he knows that he knows what are the contents of these documents. This kind of presumed or implied notice is called constructive notice. So what is constructive notice? Whether a person reads the documents or not, he is presumed to have knowledge of the contents of the documents. He is not only presumed to have read the documents, but also we presume that you have understood them in their true perspective. And not only MOA and AOA, every person dealing with the company not only has constructive notice of MOA and AOA, but also of all other related documents such as special resolution, etc., which are required to be registered with the registrar. See, all kinds of documents are not required to be registered with the registrar. But those documents which are required to be registered with the registrar, we assume that for those documents you have the knowledge of those documents, you have understood the contents of those documents, right? Now say for example there is an internal document which is about pricing policy of the company. Are you presumed to have knowledge of the pricing policy? No, because pricing policy is not to be filed with the registrar, right? Why a company would file the internal document of the company with the registrar? So you are not presumed to have knowledge of the pricing policy, but only for those documents which are filed with the registrar, you are presumed to have knowledge of those documents. Thus, if a person enters into a contract which is beyond the powers of the company, and where are the powers of the company defined? As defined in the memorandum, or if the contract is outside the authority of the directors as per the memorandum or articles, he cannot acquire any rights under the contract against the company. If I enter into such a contract which is outside the power of the company or outside the powers given by the memorandum and articles to the directors, then I cannot have any rights against the company. That is the doctrine of constructive notice, right? Coming to doctrine of ultra vires. Now, what does ultra vires mean? Constructive notice तो इतना ही था. What does ultra vires mean? Ultra vires means doing something which is beyond the specified power, right? Doing something which is beyond the specified power. The meaning of term ultra vires is simply beyond their powers. So the legal phrase ultra vires is applicable only to acts which are done in excess of the legal powers of the doers. This presupposes that the powers in their nature are limited. So a company cannot do any type of activity, but it is limited as per given in the object clause of the memorandum. If something is done which is outside the object clause of the memorandum, if something is done which is outside the MOA, it is called ultra vires the MOA, or this is also called as ultra vires the company. Okay. If something is done which is outside the articles of association does not specify the power to do this act, but the company does anything like that, that is called ultra vires the articles, right? And if directors have done something which is outside the power of directors, then that is ultra vires the powers of directors, right? So there can be these three kinds of transaction which can be ultra vires. So it is a fundamental rule of the company law that object of a company which are given in the memorandum, they can be departed, that is the company can move away from the object clause only to the extent which is given by the act, right? In consequence, if any act is done or a contract is made by the company which travels beyond the powers not only of the directors but also of the company. Also of the company means what? Outside the object clause of the company in the MOA, then it is wholly void and inoperative in law. So what is important is such a transaction which is outside the MOA or outside the object clause of the company, ultra vires the company, is inoperative in law, it is void, and therefore it is not binding on the company, right? On this account, a company can be restrained from employing its funds for the purposes other than which are stated in the object clause. Likewise, it can be restrained from carrying on any trade which is different from the one it is authorized to carry on. The impact of doctrine of ultra vires is that a company can neither be sued, no one can file a case against the company on an ultra vires transaction, and nor can it sue on it. Company also cannot file case on third party if the transaction entered into is ultra vires the company. Since the memorandum is a public document, now where does this come from? Constructive notice. Since the memorandum is a public document, it is open to public inspection. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If in spite of this you enter into a transaction which is ultra vires the company, you cannot enforce it against the company, right? So constructive notice pehle kyun liya? Now you must be getting, because ultra vires has a reference of what is given in constructive notice. Say for example, what example is given here? The same which I gave. You purchase laptops from the company, but the object clause of the company states that the company is made for the business of construction business, right? So you cannot purchase laptops from such a company because it is outside the powers of the company to do so. This is an ultra vires transaction. You also cannot sue the company if the company fails to provide the laptop, and company also cannot sue you if you fail to provide the money given to for the order you have given to the company, right? Now we have discussed three types of transaction. If it is ultra vires the MOA or ultra vires the company, it cannot be ratified even by unanimous consent of the shareholders. But if it is ultra vires the AOA, it can be ratified by the shareholders by passing a special resolution. And if it is ultra vires the powers of directors, then it can be ratified by passing an ordinary resolution by the shareholders. An act which is ultra vires the company being void cannot be ratified by the shareholders of the company. Sometimes an act which is ultra vires can be regularized by ratifying it subsequently. How? But before that, before doing the act, you will have to alter the MOA. If the object clause is not permitting, then first you will have to alter the MOA by passing a special resolution, and in some cases the the tribunal's order is also required if you want to alter some clauses of the MOA. And for instance, if it is ultra vires the power of directors, the shareholders can ratify it. If it is ultra vires the articles, the company can alter the articles. If the act is within the power of the company but it is done irregularly, shareholders can validate it. Yes, clear? Three types of transaction, and when can the act be ratified, that must be clear. Now the case law, important case law which you should remember for this case is, whenever the doctrine of ultra vires comes, you can quote this case law of Ashbury Railway Carriage and Iron Company Limited versus Riche. Now what this case law is, this person Riche, he was into some business and he wanted loan for construction of railway line. He wanted loan for construction of railway line from this company Ashbury Railway Carriage and Iron Company Limited. Now this Ashbury company also agreed to give loan to this person Riche, right? But now understand, what does doctrine of constructive notice mean? That Mr. Riche should first read the documents of the company. Which documents? MOA and AOA, the public documents, and he should ensure that this transaction of financing done by whom? This company, और किसको financing दिया जा रहा है? Riche को. It should be within the object clause of the company. Now, before going into object clause of the company, I would like to give you a simple example. If the object clause states that the company is authorized to sell laptops, mobiles, furniture, household items of the like, description, और say for example furniture के साथ और कुछ लिख देते हैं, furniture along with it say TV, then your washing machine. So and other items. If I say and other items, what does it mean? Anything like toothbrush, toothpaste also, or what? No, when you mention and other items, it has to be read in accordance with whatever is written previously. So now here all the household furniture and the electronic gadgets are written, right? So and other items means the similar items. So now look at the object clause of this company. Which company? Ashbury Carriage. The main object of the company were to make, sell or lend on hire these things, to carry on the business of mechanical engineers and general contractors, purchase, sell, lease and work, mines, purchase and sell, etc. These things, right? What is important for us is the case has happened due to this clause. Now the directors of the company entered into contract with Riche for financing the construction of railway line in Belgium, which the Riche was going to do. And the company further ratified this act of directors by passing a special resolution. So directors have also ratified this act. The company, however, afterwards repudiated the contract as being ultra vires. Now, after entering into contract, what the company is saying, we want to repudiate the contract because giving finance is not in our object clause, it is an ultra vires transaction. And now what Mr. Riche is saying, no, you will have to finance my project because you have entered into the contract and this is not an ultra vires transaction because your object clause mention that you are also a general contractor. Now, does general contractor mean doing any type of contract? No, it has to be construed with the previous words. Which previous words? Business of mechanical engineers and general contractors. And Riche brought an action for damages for breach of contract. His contention was that contract was well within the meaning of the word general contractors and hence within its powers. Moreover, it had been ratified also by the shareholders. However, it was held by the court that the contract was null and void. It said that the terms general contractor was associated with mechanical engineers That is, it had to be read in connection with the company's main business. If the term general contractors was not interpreted in this way, then that would mean that company can enter into any transaction and every kind of contract or of any description, for example, marine and fire insurance. Is that possible? No. So this transaction was an ultra vires transaction. It is ultra vires the company, ultra vires the MOA. So it cannot be even ratified by the shareholders. An ultra vires transaction can never be made binding on the company. It cannot become intra vires by reason of estoppel or all these things. What is important for us is it cannot become intra vires by reason of ratification also. First you will have to amend your object clause and then only enter into the transaction, then it will become intra vires transaction. So the whole position, now what is the summary of the ultra vires doctrine? When an act is performed which, though legal in itself, it is not an illegal act, if it is not authorized by the object clause of the MOA or by the statute, that means if it is outside the company's act, it is said to be ultra vires the company, hence null and void. An act which is ultra vires, company cannot be ratified. The company cannot ratify even by unanimous consent of all the shareholders. An act which is ultra vires the directors but intra vires the company, that means it is intra vires the MOA, that can be ratified by the members of the company through a resolution passed at general meeting. If an act is ultra vires the articles, it can be ratified by altering the articles by a special resolution passed at a general meeting. But now you will understand this doctrine of ultra vires. This doctrine is giving protection to whom? It is giving protection to company, right? Even the doctrine of constructive notice, it is giving protection to company. It is saying that the public is presumed to have knowledge of the MOA and AOA, right? But we will now look at the last doctrine, doctrine of indoor management, which is to protect the interest of the outsiders. The doctrine of indoor management is the exception to the doctrine of constructive notice. What was constructive notice for? Protecting the company. Now indoor management is to protect the outsiders. The aforesaid doctrine of constructive notice does in no sense mean, constructive notice does not mean that outsiders are deemed to have notice of internal affairs of the company. So what are the outsiders deemed to have knowledge of? They are deemed to have knowledge of the public documents, but whatever is the internal affair, whether the resolution is passed or not, whether the resolution is passed properly, whether it is matching with the internal rules of the company, that is not the duty of the outsider, right? So that is what indoor management is saying, that constructive notice does not mean that outsiders are deemed to have knowledge of the internal affairs of the company. For instance, if an act is authorized by the articles or MOA, what outsider will see? Yes, it is authorized by MOA, AOA, okay. But if it is outside the MOA and AOA, then the outsider will be punished. But if it is within authorization of articles and MOA, an outsider is entitled to assume that all the detailed formalities for doing that act, the detailed internal formalities, outsider can assume that these detailed formalities have been complied with by the company. This can be explained with the help of a landmark case. So for ultra vires, you have to remember the case law Ashbury Railway Carriage and Iron Company Limited versus Riche. And for doctrine of indoor management, you should remember the case law of Royal British Bank versus Turquand. So this internal management rule, internal management doctrine is also known as Turquand rule. Now what was this case law? There was this company who wanted a loan from Royal British Bank. Now company gave this loan, bank gave this loan to the company of say $500 for now, and the company issued bonds. What does bonds mean? That the $500 will be returned after so and so period, that will be mentioned in this bond, right? So in short, the bank has given loan to the company and company has issued a bond. Now the company went into, before repayment of this loan, this company went into liquidation and a liquidator was appointed. His name was Turquand. Now what is the duty of this Turquand? He will take all the assets of the company into his custody and he will sell those assets and repay the liabilities. Now this Royal British Bank came to Turquand that you are the liquidator of this company, kindly pay our loan also, right? We are also creditor of the company. Turquand checked the documents on which basis the loan was taken, and he saw that yes, the authorization needed by the directors, the resolutions, everything has been passed, but the resolution does not mention the loan amount. And now what he is saying, that the resolution has not been passed properly, so this is an ultra vires transaction, and this company will not refund the loan to you. It will not repay the loan to you, right? Royal British Bank went to the court, and it was held that it is not the bank's matter to look into it whether the resolution has been passed properly. If it is within the MOA, within the AOA, and if it has been done with the authorization of the directors, we are entitled to assume that the internal affairs have been, internal rules and regulations have been followed, and the loan was taken properly, right? So that is the case. Mr. Turquand was the official manager or liquidator of the insolvent so and so company, right? The company had given a bond of £2,000 to the Royal British Bank, which secured the company's drawings, whatever. Now, what is important for us is here, held it was decided that the bond was valid. So, the Royal British Bank, now here also, this also we'll have to read. When the bond was under the company's seal, signed by 2 directors and secretary. When the company was sued, it alleged that under its registered deed of settlement, that is articles, directors only had power to borrow up to an amount authorized by a company resolution. A resolution had been passed, but it did not specify how much the directors could borrow, right? But it was held that the bond was valid. Royal British Bank could enforce the terms. He said the bank was deemed to be aware that directors could borrow only up to the amount resolutions allowed. Articles were registered with the companies, so there was constructive notice. But the bank could not be deemed to know which ordinary resolution passed because these were not registrable. The resolutions are not registered with the registrar, right? Right. So how would the bank know if the resolutions have been passed properly with the amount mentioned? That is not the duty of the bank. They are entitled to assume that these internal procedures have been followed properly. The bond was valid because there was no requirement to look into the company's internal workings. This is the indoor management rule, that the company's indoor affairs are the company's problems. So we have now finished off doctrine of constructive notice, doctrine of ultra vires, and doctrine of indoor management. I have taken a bit in detail so that if a question at all comes from any of the 3 doctrines, you would be able to explain in detail properly. Right. Now the last topic which is remaining is exceptions to doctrine of indoor management. That means the outsider in these 3 cases will not get the benefit of internal management, and the outsider cannot enforce any liability or any contract against the company in these 3 cases. Which 3 cases? Actual or constructive knowledge of irregularity. If there is any internal irregularity and you yourself know that there is something irregular, right? Say for example, you know that the resolution has not been passed but it is required to be passed by the AOA, then you are actually having the knowledge of the irregularity, you cannot take the benefit of indoor management. Then comes suspicion of irregularity. If you have a suspicion of the irregularity, right? Say for example, you go to a company and you want to buy the company's assets. Now, you should know that the selling authority of the assets, selling the assets is not a regular job. It cannot be done by any employee of the company. If the employee is making a contract with you to sell the assets of the company, you should have a suspicion in your mind that there is something irregular. This transaction might be outside the authority of this person, and so you should have a doubt over this irregular transaction. In that case, if you still enter into transaction, you will not get the benefit of doctrine of indoor management. And the last case is forgery. Forgery means simply, ये किसका तो साइन है, ठीक है, मैंने कर दिया. If I do somebody else's sign, I authorize a document which is not my authority to do so, and if I still do it, that is forgery. So if forgery is the case, then it is a null transaction, and in case of forgery, doctrine of indoor management is not applicable. We will quickly have a detailed look. Exceptions to doctrine of indoor management. The aforesaid mentioned rule of indoor management is important to persons who are dealing with the company, but an outsider dealing with the company, in this case of indoor management, is entitled to assume that it has been done in the manner required. But the above mentioned doctrine of indoor management or Turquand rule has limitations of its own, that is to say it is inapplicable in the following cases. First, actual or constructive knowledge of irregularity. The rule does not protect any person when the person dealing with the company has notice. That notice can be actual or constructive notice if the person dealing with the company has notice of the irregularity. Now this case law is given. What does this case law say? Say for example, a director has taken debentures from the company. Now if the debentures required the some say ordinary resolution to be passed, and this ordinary resolution was not passed before the issue of the debentures, can the director afterward claim that ordinary resolution passing is an internal management of the company, internal affair of the company, and I should get the benefit of doctrine of indoor management, right? This is not the case. If the directors are being issued, if the directors have taken debentures from the company, they should have the knowledge of the internal affairs of the company because they are themselves involved in the internal affairs, right? Where the directors could not defend the issue of debentures to themselves because they should have known that the extent to which they were lending money to the company required the assent of general meeting, which they had not obtained. So now the directors here in this case themselves have the knowledge of actual knowledge of irregularity, right? So they cannot take the benefit of doctrine of indoor management. Suspicion of irregularity. The doctrine in no way rewards those who behave negligently. Where the person dealing with the company is put upon an inquiry, for example, where the transaction is unusual or not in the ordinary course of business, it is the duty of outsider to make the necessary inquiry. Right? If you do not make the inquiry and do the transaction negligently, the benefit of indoor management is not applicable. Now, what was this case? This case, see, as in the case of Anand Bihari Lal versus Dinshaw and Co., the plaintiff accepted a transfer of company's property from its accountant. I already gave you this example. The transfer was held void. The plaintiff could not have supposed. How can you suppose in the absence of power of attorney? The accountant has not even shown you the power of attorney, that is authorization that I can sell the assets. Such authorization is also not shown to you, and still how can you believe that the accountant has the authority to sell the property? The plaintiff could not have supposed in absence of power of attorney that the accountant had authority to effect transfer of company's property, right? Here you have behaved negligently. Forgery. The doctrine of indoor management applies only to irregularities which might otherwise affect a transaction, but it cannot apply to forgery, which must be regarded as nullity, right? Say for example, a share certificate, this case law, Ruben versus Great Finland, Fingal Consolidated. In this case, the plaintiff was transferee of a share certificate issued under the seal of defendant's company. Say for example, Mr. A transfers shares to Mr. B. The share certificate was in the name of Mr. A. Now this certificate itself was a forged certificate. The seal was forged or the sign of directors was forged. And he transfers this certificate, he sells the shares to B. Now when B goes to the company to get the share certificate in his name, the company denies the transaction. Now B claims that I cannot know what is the internal procedure or what irregularity is done in this share certificate. It is an internal matter of the company. Can Mr. B benefit from this? He could if the doctrine of management was applicable, but in the case of forgery, doctrine of indoor management does not apply and the company will not be held liable. You cannot enforce this share certificate. You cannot ask them to amend this share certificate and give you the new certificate. This transaction is null. The doctrine of indoor management is not applicable in this case. See, the plaintiff contended that whether the signature were genuine or forged was a part of the internal management, and therefore the company should be stopped from denying genuineness of the document. What this person is saying that the signature, if it is genuine or forged, that is not my problem. It is an internal affair of the company, and therefore the company should be stopped from denying the genuineness of this share certificate. Company should accept it as a genuine certificate. It is not my problem. But it was held that the rule has never been extended to cover a case of complete forgery, right? So exceptions, there can be a direct theory question, explain doctrine of indoor management and its exception. You know what to write in doctrine of indoor management, you know about the case law, right? And you also know which case law, Royal British Bank versus Turquand, and which case law was there in the case of Ultra Vires, it was Ashbury Railway Carriage and Iron Company Limited versus Riche. And what are the exceptions to Doctrine of Indoor Management? Forgery, suspicion of irregularity, actual or constructive notice of irregularity. I hope now the Companies Act